Specification and quantification case law. So this ties into section F mainly because that's where we would want to see most of the specification and quantification. EC versus North East Lincolnshire LA 2015 and 2016. The said tribunal should not simply approve or endorse a vague statement or EHCP plan without proper scrutiny. So if it's woolly, doesn't make sense, not enforceable, there's room for big error, for things not to be delivered and the provisions not secure, the tribunal shouldn't endorse it, they shouldn't approve it, they should be looking at needing more specificity and quantification to make sure that it is enforceable and is going to work. London Borough of Illindown v APNSP 2024. The same tribunal may draw on its specialist expertise to determine the wording of an EHCP plan, ensuring it is sufficiently clear and precise for professionals delivering the provisions to understand what is required in practice. So the said tribunal so the judge and the panel can use their own expertise to determine the wording. So they wouldn't necessarily be making up their own wording as such or changing stuff so provision is not there or adding provision as such, but they can add wording or alter wording to make sure that it is sufficiently clear and precise for professionals and that it is understandable so it is able to be actually implemented as it should be. London Borough of Redbridge versus HO 2020. This confirms that where it is reasonably possible to include detail in an EHCP plan, it should be provided. Even where some flexibility is needed to respond to the child or young person's needs, the local authority remains under a duty to clearly specify the provision. So when we often hear them talking about flexibility and the need to make sure it's flexible, yes, if there is a need to be flexible, but it still should be clearly specified on what it is that the provision is, how often they need it, etc., who's going to deliver it. R versus the Secretary of State for Education and Science, ex parte E 1992. Statements, now EHCP plans, must not be expressed in vague terms. In addition, the local authority must ensure that special educational provision, now set out in section F, is specified for each and every special educational need identified in section B. So, again, it shouldn't be vague, it should be clear. All needs must have provision to support them, and each and every provision and need should have an outcome as well. So that's where we talk about that golden thread. Worcestershire County Council versus SE 2020. This confirms that the required level of detail and specificity in an EHC plan will depend on the particular facts and circumstances of each individual case. So there cannot be any catch-all statements. There cannot be any blank statements that the local authority have, like template statements that they put in, because the detail and level of specificity in a plan is all dependent on the child's needs.